All right, and yesterday, before we adjourned for the day, the state did rest on their case, and so, Mr. Berry, I will allow the defense to proceed.
Thank you, Judge. I have spoken with Matthew about whether he would wish to testify. It's his wish that he not testify. No, the court didn't want to ask him about that, but at this point, he does not want to testify.
Okay, thank you, Mr. Berry. There are a few questions that I would like to ask Mr. Lanz to inquire about his decision on whether he wants to testify or not. And so, Mr. Lanz, if you raise your right hand for the court, please, sir. Do you swear and affirm that the testimony you will give to this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
No comment.
Okay, can you put your right hand down for me? Mr. Lanz, do you understand that you have the right to testify, and if you want to testify, that no one can prevent you from doing so?
No comment.
Do you understand that no one can make or compel you to testify? That is, do you understand that you have a right to not testify if you do not want to?
No comment.
Do you understand that you and not your lawyer must personally decide whether you will testify or not?
No comment.
Do you understand that if you do not testify, then upon your request, the court will not use your decision against you?
No comment.
Do you understand that if you choose to testify, you will be examined by your counsel and cross-examined by the assistant district attorney?
No comment.
Do you personally want to testify or not?
No comment.
Okay. Attorney Berry, do you stand in your place as an officer of this court, as well as Mr. Lanz's representative, that you have spoken to Mr. Lanz, that you have presented him with the option of whether or not he has the right, or he has the right to testify or not, and all of the issues or concerns with whether he does or does not testify, and also informed him that if he chooses to not testify, then the court will not hold that against him. But if he were to choose to testify, then he would be examined by you as well as the assistant district attorney. Have you spoken with Mr. Lanz and discussed all of this with him?
I have, Judge, and it's his wish not to testify.
All right, thank you. Are there any witnesses that the defense wishes to call?
No, Your Honor.
Okay.
Yes.
All right. Can I have the attorney's approach? All right, before we move into closing arguments, are there any other issues or concerns that we need to deal with?
Just for the record, I think that we would need to go to the directed verdict based on that.
Okay. All right. Having heard the evidence that has been presented here, the court is going to deny the directed verdict if there is enough evidence, at least for the court to consider a judgment in each of the counts that have been presented before the court. Right.
I believe this is unnecessary.
Right. So, state, or do you intend to do an open and close, or are you going to waive openings as far as the closing arguments are concerned.
Yes, Your Honor, we will waive opening and just reserve closing.
Okay, thank you. Attorney Barrett?
Thank you, Your Honor. Your Honor, I'm not going to belabor too much the evidence, but there are some concerns that the defense has, and I'd like to go over those with the court. And I think it's important to let the court know in the statements that Scott and Teresa Lanz made and the telephone calls that the state through the cell records found. I think it's important to know that Mr. Lanz, Scott Lanz, was residing in Washington because he worked there. I think that was brought out. And he had called his son the night before, called Matthew. Matthew indicated that he would be coming home. He did not come home, according to Teresa Lanz. And because of the fact that he didn't come home, like her husband told her that he might.
Sorry, I'm having a little difficulty hearing you, Mr. Bailey.
I'm sorry.
I'm having a little difficulty hearing you.
I'll move this over.
Appreciate it, thank you.
Because of the fact that Matthew did not arrive, she became concerned again calling. And because of the fact that he did not respond, she and her daughter both began to call and were not able to get a hold of Matthew. I wanted to make it clear that there was nothing said concerning the fact that she believed that he had committed these crimes. She went there because of the fact that she felt that she needed to do a safety check on him because she hadn't been able to get a hold of her. So I wanted to make that clear in the beginning. Let's start with the crime scene. When the officers came to the crime scene, the first thing that they noticed, of course, after Mr. Hicks, the father, had noticed the back window being broken out, the officer came, and I remember seeing on the video that he took his baton and broke out a good bit of the window. There was a lot of jagged pieces still in the window. I questioned him about the area that he would have to climb through. He said, well, I had on a jacket, so I felt it might be unsafe to try to get in without knocking over the glass. I think that becomes important because you can see the size of Matthew. He would have had to step over that area and not be cut from the glass. Didn't attempt to knock out any more of the glass, so it would have been difficult to get in that window without either cutting yourself without breaking some more of the window out. When they got into the residence, the items that were collected were the 3 shell casings. The officers looked for footprints, fingerprints, all manner of trace evidence. None of the trace evidence was found. They didn't find anything that would tie Matthew to being inside that house. As a matter of fact, the report occurred, the shell casings were tested, and there was no DNA of Matthew found on the shell casings. So nothing was found at the scene would tie Matthew to the interior of that scene. As a matter of fact, the only DNA that came off of the shells was the child, Jacob's, which we could see that most of those shell casings were probably moved around by him. We saw in the bathroom that the toilet seat was up. There was some toilet paper on the floor, and it appeared to have other items there. When I asked the officer if it was possible that he could have flushed those shells down the toilet, the officer indicated that that might be possible. Shell casings were never found in Athens or any other place. So as far as count 13, I don't think the state has carried their burden on proving that those shell casings were taken from the home. The next area of concern, of course, is the firearm. It does have Matthew's DNA on it. It's a little confusing, the manner in which the gun came to be in the possession of the father. He indicated to the police that the clip for that gun and the gun itself were in the coat pocket, and they did retrieve it. But there was no testimony that I can remember whether there was a clip inside the gun at the time that it was collected. So I'm not sure whether there was a clip ever found in the gun or not, or whether that clip actually fit into the gun. That becomes important because the state wants to try to tie the clip that they found in Athens that had, I think, 5 shells missing. Of course, Matthew in his statement indicated that he had been to the range and fired the gun, but they did not pinpoint exactly when that would have been or where he had gone to the range. They may have been able to find out had they asked that information, whether in fact he had or not. The bullets were the SIG 9mm. When I asked the officer, he said those were very common for 9mm. The next item that we're concerned about is Detective Smith's testimony about the headlight signatures. He indicated this V signature that he saw. I questioned him about the signature. He did not know what kind of vehicle that Matthew Lanz had. He said, I don't know what kind it was. I was only concerned with whether that particular vehicle fit what I saw on the road. So he was not able to testify that all 2008 Lexus would have that same V signature, or whether there's any other vehicles that might have that V signature. Not just that particular. It's not like a fingerprint. It's a V signature from the headlights. But we don't know how many other cars there may be that has that particular type of V. The other area that Detective Smith talked about was the floodlights that he saw coming on and going off. And as he testified, at 9:31, the back floodlights came on. They came on again at 9:55, and again at 10:08. We found through the Celebrex that Ms. Hicks had been on her phone at 9:59, which is about 4 minutes after the back floodlights had come on. We don't know much about those back floodlights because nobody tested to see how long they would stay on or what range they had when they did come on, which is very important because if in fact they are saying that the person went in at 10:08, we don't have anybody coming out after that. If they went in to the house at 9:55, they would have had to have been in the house for 4 minutes in order for Ms. Hicks to use the telephone. So that wouldn't really make a whole lot of sense. So begs the question, did somebody go into the house earlier in the day and was laying in wait for them to get into the house and get comfortable before they made their move? So it's an interesting question, especially the fact that you don't see any corresponding exit floodlights because any movement either in or out should show. It's interesting also that the car that they are indicating was Matthew's passed by a neighbor down the street at 10:11:32, which is about 1.5 minutes from the 10:08 going into the home, which meant that a person would have to get in, knock the window out, step over a gate, which the gate was up, apparently, because we see that the gate is pushed from the living room back rather than being pushed from where the person came in forward to be able to get to where the shots were fired. So how would a person accomplish that? Get back out of the house, get to the car in 1.5 minutes. It's pretty difficult to be able to do that. We know that there was a lot of glass that was knocked out. We asked about the clothing that Matthew had on. There was no glass shards found in any of his clothing. There was no glass shards found in his vehicle. We don't know whether the shoes that he was wearing was what he was wearing supposedly the night before. We do know that he had to walk a mile or so, maybe 2, to get to the home in Sandy Springs that he was ultimately arrested. We don't know whether he picked up any glass shards on that trip from where he left his car. And we don't know whether these glass shards would match with the glass, double pane glass that was apparently there at the Hicks home. So there was no comparison of the glass shards to see whether or not they might be similar or the same, or whether it was pieces of glass that came out of a car window on the side of the road. So we don't have any other glass shards that had been found. And the state made a point to indicate that he had put his phone on airplane mode to avoid people knowing where he was. That wasn't done until 10:15. Doesn't make much sense if you don't want people to know where you're going, then why not put it on airplane mode when he was going there rather than when he was leaving? Doesn't really make a whole lot of sense. What's concerning too is that if you break one of those panes of glass out, obviously, I asked the officer, it's going to make a lot of noise. They also had a dog that the court heard in the video that went crazy when the officer came in. With the knocking out of the glass and the dog barking and the light coming on, apparently Mr. Hicks didn't have enough time but to stand up, which doesn't make a whole lot of sense either, which might be something to consider, whether somebody could have come into the home at an earlier time and laid in wait. We can simply ask the court to look at all the evidence in the case, and I know the court will, and to evaluate that evidence and testimony, and to render a verdict that speaks the truth. That's all that we can ask. Thank you, Judge.